My name is EdwardBostedo, and I will be presenting my thesis on to make a change or to not make a change, a very legal question. Within the theater, who has the right to make a change to an artist's copyrighted material? A very important question. With a definite answer, only the original artist who possesses the copyright. But at times, the legal contracts with the directors, choreographers, lead up to a question about materials added to works of art. And who possesses such materials? Upon my completion of the entertainment business program at Full Sail University, my career goal is to be a producer. I will be the individual to make the decisions regarding how a show is presented, and also to accept the full legal responsibilities for the production. In researching this topic, I discovered recent cases that were resolved before they ended up in the courtroom. I reviewed copyright laws regarding artist privileges, and I reflected on my own personal experiences working in the theater. The United States Copyright Office provides a government website with many sources regarding copyright laws for the United States and also for international copyright protection. A publication entitled Copyright Basics, providing information about what can be copyrighted and by whom. What is copyright? The Copyright Act of 1976 states, copyright is a form of protection provided by the laws of the United States, Title 17, U.S. Code, to the author of original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. This protection is available to both published and unpublished works. Section 106 of the 1976 Copyright Act generally gives the owner of the copyright the exclusive right to do and to authorize others to do the following. And regarding live theater, here are a few points that the copyright owner can commission. He or she may prepare derivative works based upon the work or give permission to have their work performed publicly. Most importantly, the Act states it is illegal for anyone to violate any of the rights provided to the copyright laws to the owner of copyright. According to the law office of Gordon P. Firemark, an entertainment lawyer based in California, in 2006, the director, choreographer, and set, lighting, and costume designers of the original Broadway production of Urinetown pursued claims against two Midwest theater companies for allegedly copying their work without authorizing. With Playbill, a renowned theater production or publication, reporting that one of their theater companies filed a lawsuit against the Broadway team, claiming their production of Urinetown was substantially different from the Broadway's production. The companies arose after the choreographer won an award for the Urinetown production at Chicago's Mercury Theater. A lawyer for the Broadway team sent a letter demanding the choreographer return the award, or court actions would be demanded. In 2008, settlements were reached in both cases. with undisclosed sums being paid to the Broadway team with acknowledgments that similarities occurred. In 1994, another theater case took place in Chicago. The directors from the Lincoln Center production sued after sets were rented from the Lincoln Center and the Chicago production used details of his work, including dialogue changes and restructured scenes without his permission. The director won. The case was settled before it went to trial, and the terms of the settlement were kept confidential. The director wins. Earlier I discussed copyright laws of the playwright obtains the copyright for their work. Under almost every playwright's agreement for the production of the show, the playwright is guaranteed ownership of all materials added by the production or by the producer, and the direction of the play is considered derivative work. So therefore, shouldn't it be the playwright who should have won in this case? The lesson is very clear for the producers. By just obtaining production rights from a publisher such as Samuel French or MTI, it does not provide permission to copy all or part of a Broadway or off-Broadway or any other original production. It is obligatory for the producer to either obtain such rights separately, or better yet, reimagine the show and create a new, original production from ground up. When in doubt, consult a lawyer.